Hello students, welcome back to the intellectual property rights classes. Today we are going to discuss with industrial design. So let's start. What do you mean by industrial design? A design which is applied to a commercial product or any article is called as industrial design. Now whenever you want to buy any article, any bike or anything which you want to buy new, what attracts you first? You will be always looking at the design. Once you get satisfied with the design of that particular product, then you think of how much it will cost, okay, and so on. That's the way of buying a particular article nowadays. So design play a very, very important role, and that design needs to be protected by law. Now we are going to discuss how a design is applied to a particular article and how it is protected by way of legislation. Okay, so one can observe the product by their visual appearance that catches your eyes. This visual appearance is called as industrial design. The design play important role in shaping the buyer's preference for the article. So what do you mean by industrial design? An industrial design, or simply a design, is the appearance of the whole or part of the product resulting from features like, in particular, lines, contours, colors, shape, texture, and or material of the product itself and or its ornament. So design is nothing but it's an art which is applied to a particular article, which attracts the consumer's eyes. Okay, and then we go for a particular product. Now design can also be the product itself. Okay, now for example, if you can see this polo mint, okay, then the golf bat heads, okay, and so on. Okay, so industrial design is nothing but it's a design applied to a particular commercial product. What do you mean by design as far as definition is concerned? So section 2D of Designs Act says that design means only the features of shape, configuration, pattern, ornament or composition of lines or colors applied to any article, whether in two-dimensional or three-dimensional or in both forms, by any industrial process or means, whether manual, mechanical or chemical, separate or combined, which in the finished article appeal to and are judged solely by the eye, but does not include any mode of principle of construction or anything which is in substance a mere mechanical device, and does not include any trademark. So this is the definition of design. Now, essential of a valid and admissible design. Now, before that, we come to the act which is made applicable to this particular intellectual property, which is called as Designs Act 2000. So that is applicable for industrial designs. Okay, what are the essential requirements for a valid design? The first is novelty. Novelty or newness is an essential requirement of an admissible design. As per the Designs Act, a design is registrable only when it is new and original and not previously published. So it is just like patent. Okay, so patent also, an invention, in case of patent, the invention must be new. New means it should not be already known to the public, or it should not be already published in the past. So similarly, design also should be a new one. Now in one case, Pilot Pen Company versus Gujarat Industries Private Limited, court held that registration could not be deemed to be effective unless the design is new or original and pre-existing common type. But as per the Act, the combination of previously known designs can be registered if the combination produces a new visual appeal. Now, always it is not possible that every time you come up with a new thing. It can be a combination of old designs and coming up with a new design. For example, a car. Car is basically, the design of a car is simple. There is a body, and then there are four wheels, one steering, window panels, then doors are there, bonnets are there, then whatever. The structure, main structure is basic structure, but the design differs. Okay, but the functions of each and every part of car is similar. Okay, so it can be a combination of old design, but whatever is the finished product, it should be new one. Okay, then only design can be protected under Designs Act. Okay, next condition is no prior publication. The design should not be published previously. If a design is made available to the public, then it constitutes publication of design. So it should not be known to public earlier. Now, in one case called as Vimco Limited, Bombay versus Meena Match Industries, Sivakashi, the court held that publication means the opposite of being kept secret. It is considered published if a design is no longer a secret. There is a publication if the design has been disclosed to the public or if the public is in possession of the design, and any such previously published design cannot be registered. Next, the design must be applied to a particular article. So this is the third condition. It should be capable of being applied to an article. Then only it will be a registrable design. A design is admissible if only it is incorporated in an article. It should be part and parcel of the article, or it should be applied to the article. It can be either three-dimensional or two-dimensional article or the design. The design should relate to features of shape, configuration, pattern, or ornamentation applied or applicable to an article. Hence, the industrial plan designs, layouts, and installations cannot be taken as design under the Act. So, layouts, design layouts, and installation. Now, these things do not form part of the article, so they cannot be called as designs. Then, next condition is the design must be visible on the finished article. A design should be applied or appealed solely by the eyes of the consumer. This means a design, in order to qualify, should be visible on a finished article. Now you can see in examples of so many mouse designs of the mouse. You can see the shape of the mouse. It is visible. See, the design is visible on the product itself. Okay, so it has been applied on the product itself. That means this is design. Okay, the product is basically same. Mouse, it functions exactly the same way as the other mouse work on for a computer, but the way it has been designed, it is visibly possible to see the different kinds of shapes, the different designs that may catch the eye of the consumer. For example, if you want to buy a particular mixer and grinder, you will see varieties of mixers and grinders being displayed in that particular shop. Now your eye first catches the design, the way you want that mixer and grinder to be placed in your kitchen. So you would be looking for a particular shape. That shape is called as design. Okay. For example, the inside arrangement of a closed article cannot be considered as design as per the law. Now, whatever is there inside the product is not a design. Whatever is appearing, visually appearing, or which appeals your eye, okay, it attracts to you, okay, and then you get attracted towards that particular design, and then you go for it. Then you think of quality and performance and all those things. First, you will always look for a particular design, latest model, we can say. Okay, let's go ahead. Let us come to the history of design law in United Kingdom. Because why we have taken history of UK? Because we got our law, most of the laws, almost 99% of the laws are from British. Okay, so United Kingdom is considered to be the pre-runners in protecting the industrial design. Indian laws relating to industrial designs are based on UK laws. The Designing and Printing Linen Act was the first act that was dealt with matters and protection of designs in UK. It was originally introduced to protect the designing and printing of linens and cottons. Later on, it extended to include the and governed the matters related to functional as well as decorative articles. Later on, in 1839, Copyright and Designs Act was passed in order to incorporate all the developments and progress that took place in the field of designs, printing, copyright, etc. Then came the Designs Act of 1842, provided the remedies for infringement. Thereafter, in the year 1883, a single consolidated and amendment act was passed by the Parliament of United Kingdom, clinching designs, patents and trademarks. In 1949, a separate legislation for matters related to designs, Registered Designs Act, was enacted. The act was later on amended in 1968 and 1988. In 1988, amendment was made to reduce the luxurious nature and designs right. The act was further amended in 2001 to incorporate the European Designs Directive. So that was the history of UK Designs Act. Let us come to the origin and development of Designs Act in India. The history of Designs Act in India can be traced back to the British period. The first Indian legislature to grant protection for design was the Patent and Designs Act 1872. It supplemented the 1859 Act passed by Governor General of India that protected industrial design. The enactment of Inventions and Designs Act 1888 repealed the 1872 Act and provided for the protection of inventions and designs. This act was a clear reflection of Designs Act in the United Kingdom. In 1911, British government enacted the Patent and Designs Act and repealed the prior legislations. In 1930, this act was amended. Initially, this particular legislation governed the matters related to both patent as well as design. In 1972, a separate act was passed, which was called as Patent Act 1970, and was enacted to deal with matters related to patent. So, in 1970, patent got separated from Designs Act, but the Act continued to be the major legislation for industrial designs till 2000. So, earlier Act dealt with both patent as well as design. In 1970, patent got separated and one more Act was passed, that was Patent Act 1970. But the basic law continued to protect designs up to 2000, and in the year 2000, Indian Parliament passed a separate Act which was called as Designs Act 2000. Let us come to the procedure of registration of a design. The procedure for registration consists of the following steps. First is submission of the application, then acceptance. If there are any objections, it can be refused or accepted. Removal of objections, appeal to central government, then decision of the central government, and registration of design. So this is how the registration of the design takes place. Let us come to the first step, that is called as submission of application. Under section 5(1) of the Designs Act, it is the proprietor of the design who can apply, or any person who he authorizes, like for example agent. Controller is the person who deals with the procedure of registration of designs. Okay, the office is Patents and Designs, Trademarks Office. Okay, so controller may, on application by a person claiming to be the proprietor of any new or original design not previously published in any country, not contrary to public order and morality, register the design under the Act. The application is to be accompanied by the prescribed fees and in prescribed form and in prescribed manner. Then only the submission can be accepted. Let us go to the next step. Documents to be filed with the application. The application must be accompanied by 4 copies of the representation of the design. Class in which the design falls must be mentioned. Class in the sense, for example, is it a car or a mobile or a bike or anything which is, for example, iron, okay, etc. A brief statement of novelty has to be also connected to this particular application. Let us go to the third step, acceptance or objection. On fulfilling all the prescribed requirements, the controller shall register the design. But if there are any objection received by the controller, the copy of the objection has to be sent to the applicant. Then applicant needs to remove the objection within 1 year. Applicant also can apply to the controller for hearing him. So both the parties will be heard, and if the controller finds any fault in the application, it can refuse or reject the application. On rejection of the application, the applicant can approach the central government, whose decision will be a final decision. So decision of the central government will be final. Next, publication of particulars of registered design. On acceptance of the application, for example, if the controller gets satisfied the application is correct and the registration can be proceeded, controller can direct the registration and publication of the article to which the design has been applied in the official gazette. So, news of registration of design will be published in the official gazette. The design then gets registered into the register of designs. Now, what is the registration of design? On the completion of the entire procedure successfully, the controller shall grant a certificate of registration to the proprietor of the design. Now, this is how it looks like. See, there is a seal of the patent office, then it says Government of India, the patent office, certificate of registration of design, then this is the design number, date, when it was issued, and then the text reads like this: certified that the design of which a copy is annexed hereto has been registered as the number and date given above in class 25(1) in respect of the application of such design to stud spacer, this is the name of the product, in the name of Fabtech Sterling, this is the company, Technologies International Private Limited, a company incorporated under the Companies Act 1956, whose address is so and so, so and so. Okay, so in pursuance and subject to the provisions of the Designs Act 2000 and the Designs Rules 2001, Intellectual Property Controller General, this is the signature of that particular authorized authority. So this is how the certificate of registration which will be issued to the true proprietor of the designs who had applied for the registration of design. Okay, rights granted and the term of such rights. The exclusive rights granted after the registration of the patent are called as copyright in design. Okay, but this should not be confused with the rights granted under Copyright Act. There may be certain designs which can qualify for registration both under Copyright Act as well as designs, because it includes the art. Therefore, if the design is registered under Designs Act, it cannot be protected under Copyright Act. So, any one option has to be accepted by the proprietor to apply for registration. If it gets qualified under Designs Act and it is not registered under it, then the exclusive rights will subsist under the Copyright Act. So automatically that the design will be protected under Copyright Act. So there are two ways it can be protected, but either one has to be opted for. Even though both the acts overlap, but they cannot be applied coterminously, that is at the same time. Next, rights granted. Which are the rights granted when design is registered? The rights to exclusive use of design. The first right will be to exclusive use of the design. When proprietor is subject to the provision of the Designs Act 2000 have the copyright in design during 10 years. So the period of protection is he can use it for 10 years from the date of registration. The term of protection for registration is 10 years from the date of application and can be extended for further 5 years on payment of an extension fee. And then second right is right to protect the design from piracy. That means he has every right to apply and to file a case against a person who uses his product, his design without his authorization. Now let us come to that process which is called as infringement or piracy of design. Infringement of a copyright in a design is called as piracy of design under section 22 of the Designs Act 2000. So section 22 deals with the infringement and the remedies which are available against the infringement of designs. If any unauthorized person does any of the following acts, it may amount to piracy of copyright in a design. For example, first, for publishes or exposes for sale any article on which any fraudulent or obvious imitation has been applied. That means he has applied the design of a registered design. Applies or causes to apply the design that is registered to any class of goods that are registered. Imports for sale any article in which design has been registered and to which a fraudulent imitation of a design has been applied. Now, let us come to the test. How to find out whether there is an infringement or not in two products. So they need to be compared, right? So fraudulent imitation means knowing the imitation of a registered design on his article without any permission from the true owner. The test would be the alleged infringement has the same shape or pattern. So we have to see whether both the products are same in pattern, same, everything same, apart from the basic functions of a particular product. For example, however, the court needs to ignore the functional similarity but must look at the two articles and check out their similarities and differences and find out whether the defendant's article, that is the person who has committed the piracy, is substantially different from that of the plaintiff. Now here we have an example of one parachute oil bottle and a coconut oil bottle. Now you can see that the cap is similar. Okay, the function is similar. You can just break this seal and open it, and then squeeze the bottle to pour the oil out. Now it was alleged by the parachute that Coconut company copied their cap, okay, design of their cap. But what is the decision? Parachute cap, competitors' caps dissimilar. It is not similar. Can you see this? Shape is different. Okay, the manner in which the seal is shown is also different. So there was no prima facie case made up by the parachute. The injunction was denied by the court against Coconut. Now these are some of the examples of violation of, or you can say, piracy of design. Now this is what is the original designs of the complainant which is registered. See, both here you can see a sun and then a person who is on the surf. Now this is the design of a Bayer. Bayer means unregistered design. See, similar kind of, the only thing is he has added something here, and then here also similar boy has been taken here, but with some additional imitation or alteration. Package of biased product. Now you can see on the package, this is what is being used here. This is the original one and this is the duplicate, right? You can see the similarity, right? Okay, so this is called as design violation of design, piracy of design. You can see another example. This is the design right, which is already registered, of a key shape. Another person has copied the same face of a monkey, but he has used it for some other key. See, look at this. This is the opener of maybe a champagne bottle, right? Okay, another example. See the shape of the shoes. This person has copied it. See, another shoe. This is the original registered one, and this is the copy. Again, Nike shoes have so many designs. Now the similar kind of design is copied by the another person. See, look at this. Look at the cars. The car's design is also copied by another car. Okay, see, Fiat Panda and Great Wall Paris. Now both are having some issues because of the design, similar design. Again here, Honda CRV. This is a chap in China. There was a copy of similar car here. See, Labo and Honda. Honda has filed a complaint against this Liabo company in China for copying their design. Next is, you can see Honda. This is the Honda bike and the electric Hero. They have the similar kind of design here. So Honda has filed a case against Hero for copying its products. Again, you can see here the wall clock has the similar design. Okay, right. So those were the examples of violation of design. Let us come to the judicial remedies. So what are the remedies available against the piracy? Section 22(2) of the Designs Act provides remedies against infringement of design as under. So the plaintiff can claim damages. He can also claim injunction to stop the work being copied, and can also ask for accounts of fraud. So what is the jurisdiction of the courts? Suit can be filed under Section 22, not inferior to district court or high court, but it depends on the quantum of damage. So pecuniary jurisdiction gets applied here. Let us come to the burden of proof. The part making the change has to establish, the party making the charge has to establish the occurrence of the infringement. Okay, the burden of proof is on the plaintiff. The facts that needs to be proved by the plaintiffs are that a copyright subsists in the design on the date of piracy. The design of fraudulent imitation has been applied to an article goods for which his design is registered. The design or its imitation has been applied without license or any consent from the proprietor. The article to which the design has been applied comes within the scope of description of goods covered by the registration. The application of the design by the infringer for purpose of sale of the article or gain commercial benefit from the act of the infringement. So if he can prove all this, he can prove that there is a piracy. Now there are certain defenses available on the other side. So defendant can also set up following defenses. The defendant may present evidence and argue that the plaintiff has no title to sue. The plaintiff is not a true proprietor. The design cannot be registered under the act as it does not qualify to be so registered. The plaintiff's own conduct is tainted. He was not approached by the court with clean hands. Delay in acquiescence agreement. Plaintiff himself has agreed for the infringement on the part of the plaintiff. Then expiry of the period of registration. Now the period of registration has expired, and then the plaintiff does not have any right to claim defense, so protection against the design copy of the design or violation of the design. Next, conclusion. So we can conclude that the necessity and need for the protection of industrial design in the nation, that is in India, has resulted in the so-called legislation regarding the industrial design starting from 1872, that is Patents and Designs Act, to the recent Designs Act of 2000. Designs Act 2000 is a prominent legislation in the field of intellectual property which has got a long, strong legacy and history. This act, along with other rules, efficiently controls the matters relating to industrial design. So thank you so much for being patient, and then I'll see you in the next class. Take care.